Good evening, everyone. My name is Emiliano Catan, and together with my colleagues Ed Rock and Rob Jackson, I'm a co-director here at the Institute for Corporate Governance and Finance. On behalf of the Institute, I'm delighted to welcome everyone to our 6th Distinguished Jurist Lecture. Each year, the point of the lecture is to bring together people who are basically at the cutting edge of the corporate governance developments to have a discussion about the hot topics du jour. And we are proud to continue with this tradition this year, following the footsteps of presentations by CJ Slides, Chancellor McCormick, and last year Vice Chancellor Laster, who's, I guess, joining us tonight. Welcome, Travis. So tonight, the presenter we are delighted to have with us is Justice Valihura from the Delaware Court of Chancery. So I want to thank you all for being a part. Supreme Court. I should stick to my script. Damned AI. Anyways, welcome. And welcome everyone. Thank you all for joining us. With no further ado, I'll turn things over to our Dean, Troy McKenzie. Thank you.
Thank you, Emiliano. Good evening, everyone. It's wonderful to see everyone here at NYU Law for this evening's Distinguished Jurist Lecture, hosted by our Institute for Corporate Governance and Finance. And I want to begin by thanking the leadership of the Institute, and in particular my colleagues Emiliano, Ed Rock, and Rob Jackson, who have done such amazing work. The Institute has been an incredible addition to the collection of centers and institutes at NYU Law, and it focuses on events like this one that draw leading leaders, lawyers, practitioners, jurists to discuss and dissect central questions of the day with respect to investing in corporate governance. And I really want to thank the leaders of the Institute for the work that they have put into this evening's program and so much else. I also want to thank, in particular, Nadia Janetta, who has directed the Institute with exceptional finesse and insight and dedication. We're here today because the Institute launched this Distinguished Jurist Lecture several years ago, as Emiliano said, and the goal is to celebrate jurists whose careers have shaped corporate law and corporate governance, and to highlight some of the most pressing issues of the day, going back to Leo Strine, then Chief Justice of the Delaware Supreme Court. Emiliano mentioned Vice Chancellor Laster, being our speaker most recently. And I'm proud to say that the series has quickly become a cornerstone of programming here at the law school, reflecting the importance of having jurists in an academic setting to think, reflect, and provoke as appropriate. So we'll see what happens this evening. I am delighted that we are continuing that tradition this evening by welcoming a jurist who has had a remarkable impact on corporate law and governance, and in particular, the development of Delaware law, Justice Karen Valihura of the Supreme Court of Delaware. She was sworn in as a justice on that court in July 2014, and since then has distinguished herself as a leading figure, particularly in cases involving complex corporate issues. Before her appointment, she was a partner at Skadden Arps, where she spent over 2 decades handling some of the most complex commercial and corporate matters, including matters in federal and state law, mergers and acquisitions, fiduciary duties of directors and officers, and her skills as a lawyer were widely respected in the field. Before her judicial role, she contributed in other ways to the development of corporate law and to the conversation about corporate governance. She served as a member of the advisory board of the John L. Weinberg Center for Corporate Governance. She was chair of the Delaware Supreme Court's Board on Professional Responsibility and also that court's Permanent Ethics Advisory Committee. And she carried forward her dedication to the development of the law in many dimensions to her time on the Supreme Court. She received her JD from Penn and began her legal career clerking for Judge Cowan on the U.S. Court of Appeals for the Third Circuit. And we are honored to have her here this evening. I look forward to hearing her thoughts on this evening's topic, plain language in Delaware corporate law. We've already started a conversation about the topic, and I know it will be a fascinating and perhaps a little provocative, which is a good thing. Justice.
Good evening, everyone. It's a pleasure to be here. And Dean McKenzie, thank you for that kind introduction. It's so wonderful to be here at NYU, and it's an honor to be at the Institute for Corporate Governance and Finance. Let me, after your kind introduction of me, let me introduce you to our court, our Delaware Supreme Court. We are a 5-member court with Chief Justice Seitz in the middle. Our 2 newest justices on the ends, Justice LeGros, Justice Griffiths, and then myself and Justice Traynor. And this is us in action. That's our spot in Delaware, Dover, Delaware, and that is our courtroom where you might see us on live stream or in person. I have to say my disclaimer, which is that I'm speaking for myself and not for my colleagues, and nothing I say is intended to indicate how we might rule on any case that might come before us. As the dean said, my lecture is entitled Plain Language in Delaware Corporate Law. I intend to explore the role of plain language as an interpretive guide for Delaware courts as we construe the meanings of corporate agreements, charters, bylaws, and statutes. I will discuss several recent decisions by our court and the Court of Chancery to illustrate certain points. I hope to show that discerning the meaning of words, even simple words like and, the, and can be difficult. Judges have relied upon dictionary definitions, the context of words in the corporate instrument, common usage to try to figure out the meaning of language at issue. We, as judges, need to be familiar with both ends of the interpretive spectrum, the minutia on one end with grammar and punctuation, but also discerning the overall context from the words more holistically. My experience has shown that parties and judges on the same court and different courts often disagree with each other on whether words are plain and clear. The separate opinion in our court's decision in a case called Cox Communications versus T-Mobile in 2022 ponders whether a provision is truly clear and unambiguous if panel members disagree on its meaning. There, the 3-member majority of our 5-member court, pardon me, determined that there was only one reasonable reading of the provision. 2 members thought that there were 2 reasonable readings and that the Vice Chancellor's reasoning, which differed from the majority's, was also reasonable. Differences among panel members have not precluded findings by our court that a provision can be read reasonably only one way. So does that mean some of us are unreasonable? Some courts have said that differences among panel members suggest that ambiguity exists presumptively. As you will see by my examples, corporate drafters' choice of words can either achieve the drafter's goals or can lead to judicial findings of ambiguity and unintended results. Courts in Delaware have wrestled with a number of interesting issues lately, such as what is the appropriate role, if any, of corporate practice and of settled commercial expectations in the interpretive exercise. Recent decisions have also explored how prolixity, complexity, and vagueness in corporate drafting has been perceived by courts as an attempt to create tripwires for strategic corporate advantage. I will comment on the use of boilerplate in corporate instruments, and finally, on the impact of AI and the pressure points it may be creating in the legal world, not only for judges, but for corporate lawyers. I hope to show with a bit of levity at times that when drafters carefully choose simple language, clear language to craft corporate documents, they are more likely to achieve their goals. So let's start with construing corporate contracts and transaction agreements. Many of the cases that we see in our colleagues on the Court of Chancery involve lengthy and complex provisions. And if I tried to go through these cases in any kind of depth, I would bore you to tears. So my approach in this lecture is to try to stick with some big picture points, and I'll save the more detailed discussions for my article. So let's start on the minutia end of the spectrum, where the courts in interpreting corporate instruments have had to wade into grammar and punctuation rules. Beginning with a decision our court issued in 2023 called Weinberg versus Waystar, we see the importance of common words such as and. In this case, our Delaware Supreme Court was asked to construe the meaning of and in 3 separate stock option agreements executed by the company Waystar, Inc., and its then employee, Tracy Weinberg. The answer to the question posed would determine whether Waystar had validly exercised a call right to repurchase approximately $1.8 million worth of company units from Ms. Weinberg. The word and was located in a call right provision contained in each option agreement. Now, leaving out a bunch of words for our purposes here, the call right provision provided that converted units shall be subject to the right of repurchase following X, the termination of Weinberg's employment, and Y, a restrictive covenant breach. The question was whether Waystar could exercise its call right after either the termination of employment or a breach, or only after both. At the time of the litigation, Waystar had exercised its call right, but the parties agreed that only one event, namely Weinberg's termination, had occurred. Weinberg argued that both were required and that Waystar's interpretation would turn the conjunctive and into a disjunctive or. Well, the Court of Chancery determined that the and in the call right provision was clear and unambiguous. In so doing, the court did not deny that and was being used in the conjunctive sense as opposed to the disjunctive sense, as Ms. Weinberg argued. But the court found that in the context of the option agreements and considering the call right provision was permissive, the and was being used in its several sense. Well, this is getting kind of complicated for and. This meant that Waystar had the option of exercising its call right after Ms. Weinberg termination, or after a breach, or both. The Court of Chancery held that only one event was needed, and so the company won. The Court of Chancery found that Waystar's interpretation was the only interpretation that gave effect to all of the terms in the agreements. So Ms. Weinberg appealed, arguing that the trial court had erred in failing to give and its plain and meaning as a conjunctive word. The Delaware Supreme Court ultimately agreed with the Court of Chancery that the and in the call right provision was clear and unambiguous. It provided Waystar the option to exercise the call right after either condition had occurred. Both were not required. And here's where our court had to take a deep dive into some grammar minutia. The court observed that there were 2 avenues of interpretation: the conjunctive or disjunctive path and the joint or several path have emerged. When I was preparing for this school rock song came, conjunction, junction, what's your function? Remember, I couldn't get it out of my head. But, okay, so what do I mean by several? Here's an example. The law punishes assault and battery, and is used in the several sense, that a person may be punished for committing either crime, whether the activities are done jointly or severally. So what do I mean by jointly? So the law punishes drinking and driving, and is used in the joint sense because a person may be punished for committing the two activities together, but not committing them separately. As a further illustration, our court explored the Federal Circuit Court of Appeals cases interpreting the word "and" in a federal criminal statute known as the First Step Act. As we observed, the Federal Circuit Courts divided on which avenue of interpretation to use. Notwithstanding their different interpretations and conclusions, the courts found that the "and" was unambiguous. Yet they split. Imagine that, a federal circuit split hinging largely on the meaning of "and." But even with that split, the United States Supreme Court said, there's really only one possible reasonable reading. So does that mean half of our circuit courts are not reasonable? It should be apparent that the consequences of what courts say "and" mean can be quite serious, affecting the criminal sentencing, corporate treasuries, and employees' financial positions. To put an endpoint on this Weinberg case, the Delaware Supreme Court agreed with the Court of Chancery that Waystar's interpretation of "and" as having a several sense was the only one that gave effect to all of the terms. Other examples on the grammar and minutia end of the spectrum focus on smaller words like and "the," as used in the stock purchase agreement in this Ion Geophysical Corp case versus Fletcher, where the issue was whether the A notice meant more than one notice could be issued. In this case, in November 2008, Fletcher delivered a 65-day notice increasing the maximum number of Ion common shares into which Fletcher could convert its preferred shares. Fletcher, with this notice, increased the maximum number by 2 million shares. Then later, he delivered another 65-day notice to increase the shares by another 2 million. Ion's position was that Fletcher could issue only one 65-day notice, not more than one. The Court of Chancery held that the plain language of Section 6B was clear. There was only one reasonable interpretation. Fletcher was entitled to issue more than one 65-day notice, and it noted that the article "the" was used to modify maximum number, and that the A used in the same sentence to modify a 65-day notice period was meant to be plural. Other cases like SeaWorld Entertainment versus Andrews, the Court of Chancery focused on other aspects of grammar, such as the use of parentheticals. In that case, the Court of Chancery didn't really have anything good to say about the use of parentheticals in corporate drafting, commenting that Delaware courts have described contracts that place terms in parentheticals as poorly drafted, sloppy, less than careful, potentially puzzling, and in some cases an obvious blunder. These three cases illustrate that as judges, we are often required to puzzle through complex and oftentimes less than artfully drafted corporate provisions to try to figure out what they mean. The choice of words, even like "and," "the," and and the use of punctuation can make a huge difference in the outcome of a case. And judges, even circuit court judges, may disagree and nevertheless hold there is only one reasonable reading. Well, let's go to the other end of the interpretive spectrum and take a detour into some big picture interpretive principles. Recently, in Bitco Holdings versus Galaxy, our Delaware Supreme Court commented that the basic principles that guide us when we review a trial court's interpretation of a contract are well settled. We summarized a few of these principles as follows. You've probably heard them all. Delaware courts read the agreement as a whole and enforce the plain meaning of clear and unambiguous language. Delaware law adheres to the objective theory of contracts. If a contract is plain and clear on its face, then we don't look at evidence. Courts seek to give each provision meaning, and courts should read specific provisions of the contract in light of the entire contract. You may have heard that Delaware is a contractarian state. When Delaware courts refer to themselves as contractarian, We refer to the tradition in Delaware law that protects the freedom enjoyed by parties to contract. Beyond Delaware courts and Delaware case law, the Delaware General Assembly has reinforced this principle in certain statutes. For example, the Delaware Revised Uniform Limited Partnership Act gives, quote, maximum effect to the principle of freedom of contract and to the enforceability of partnership agreements. Such provisions provide business entities like LLCs and partnerships with greater freedom to a contract, thereby allowing them to structure their relationships in the manner that best suits them and their business. Without digressing too far off of my plain language path, I pause to note the impact of Section 111 of our corporate code and the huge number of cases of contract-based disputes that our Court of Chancery and Supreme Court now handle. This provision is allowed for certain purely legal contract disputes to be litigated in a Court of Chancery, our Court of Equity, whereas before they had to be litigated in our Superior Court. There's also a new provision, Section 122.18, which was just recently enacted, which is also a new frontier in the area of contracts and corporate law. I will come back to this provision in a while. In Cantor Fitzgerald versus Ainsley, decided by our court in 2024, our court emphasized that this freedom of contract, emphasized the freedom of contract when it diverged from the common law on forfeitures and chose to uphold a forfeiture provision attached to a limited partnership agreement. However, in Cantor Fitzgerald, we also acknowledged that the freedom is not without limits. It is conceivable that a public policy interest or inequitable outcome could, under some circumstances, outweigh the interest of freedom of contract. In this regard, our court said, when parties have ordered their affairs voluntarily through a binding contract, Delaware law is strongly inclined to respect their agreement and will only interfere upon a strong showing that dishonoring the contract is required to vindicate a public policy interest even stronger than the freedom of contract. Such public policy interests are not to be lightly found, as wealth-creating and peace-inducing effects of civil contracts are undercut if citizens cannot rely on the law to enforce their voluntarily undertaken mutual obligations. But some interpretive principles may appear, at least at first blush, to be somewhat counter-contractarian. In the case Chicago Bridge and Iron versus Westinghouse Electric, our Supreme Court stated that the basic business relationship between parties must be understood to give sensible life to any contract. This suggests that the overall business context, the overall business deal, matters. But this big picture context notion was not new. Our Supreme Court in 1985 stated in the E.I. DuPont Nemours versus Shell Oil case that the meaning which arises from a particular portion of an agreement cannot control the meaning of the entire agreement where such inference turns counter to the agreement's overall scheme or plan. Recently this year, our court affirmed the Court of Chancery's decision in Soleimani versus White Oak Healthcare. The Court of Chancery applied contractarian principles to interpret a termination provision in a series of identical limited liability company agreements that used the words provided that the company has satisfied as creating a condition precedent that payment obligations in the term sheet had to be satisfied before a plaintiff could be removed as an employee and a manager. The Chancery Court opinion reasoned that the use provided in the future tense and the use of the present perfect tense, provided that the company has satisfied, in other places in the agreement, pointed to another general principle of contract interpretation in Delaware, that the use of different language in sections of a contract indicates that the distinction is intentional and that the parties intended different terms to have different meanings. The Chancery Court held that this condition precedent applied, and that meant the employee manager had to be paid for his equity stake before he could be removed from his position. Now, appellants argued that the Court of Chancery's interpretation was contrary to the basic deal structure, the term sheets, and the agreement, and led to the absurd result that where a terminated employee would be allowed to remain in the company until the payments provided in his agreement were satisfied. The Court of Chancery was not persuaded by that argument and grounded its holding in the plain language and grammar rules. Ultimately, it concluded that enforcing the plain language of the contract did not create an absurd or commercially unreasonable result because the plaintiff had negotiated for a fully vested equity stake if he devoted 5 or more years to the company. As the Court of Chancery noted, and the Supreme Court affirmed, the challenge provision says what it means and means what it says. And although the defendants did not find the outcome palatable, it was not the court's job to relieve sophisticated parties of the burdens of contracts they wish they had drafted differently. Parties have a right to enter into good contracts and bad contracts, and the court will enforce both. Let's see if I can get this. Now, let's turn our attention to some specific types of corporate instruments, charters and bylaws. Because corporate charters and bylaws are contracts, our rules of contract interpretation apply. Let's take a recent case. This year, our court decided Kellner versus the Immunotech Inc. case. On July 11, 2024, our Supreme Court reaffirmed in Kellner that under Delaware law, bylaws are presumed to be valid. A facially valid bylaw is one that is authorized by the Delaware General Corporation Law, consistent with the corporation's certificate of incorporation and not otherwise prohibited. To make a successful facial challenge, the plaintiff must demonstrate that the bylaw cannot operate lawfully under any circumstance. So what happened in this case? In Kellner, a group of AIM Immunotech stockholders thought that the board of directors was mismanaging the company. The insurgents included 2 felons convicted of wire fraud, insider trading, and other crimes. The campaign escalated into 2 attempts to nominate directors to the board. The board rejected both nomination notices under existing bylaws, which led to a lawsuit over the second notice. The Court of Chancery denied the insurgents' request for a mandatory preliminary injunction to place their nominees on the annual meeting ballot. The insurgents persisted and reshuffled their membership, with Ted Kellner leading a 3rd attempt to nominate 3 new directors to the board. The board amended its bylaws to include sweeping new advance notice provisions that required detailed disclosures by Kellner and his nominees. Many of the amendments were approved in direct response to their campaign. Again, the board rejected Kellner's nominations for failing to comply with the new advance notice bylaws. Kellner sued, and following a trial, the Court of Chancery invalidated 4 of the 6 main advance notice bylaws and reinstated the 2016 version of one of the invalidated bylaws. In the end, the court upheld the board's rejection of the 3rd nomination notice because it failed to comply with 2 advance notice bylaws left standing. Kellner argued on appeal that the trial court had erred. The defendants filed a cross appeal challenging the trial court's invalidation of 4 of the amended advance notice bylaws. They contended that the court had confused a facial challenge with an as-applied challenge, and that Kellner had raised only an as-applied challenge. According to the defendants, the court should not have invalidated the 4 amended bylaws, which they asserted withstood enhanced scrutiny in any event. In resolving the issues on appeal, we first established the framework for evaluating the issues as follows. We consider first, if contested, whether the advance notice bylaws are valid as consistent with the certificate of incorporation, not prohibited by law, and address a proper subject matter. And second, whether the board's adoption, amendment, or application of the advance notice bylaws were equitable under the circumstances. In applying this framework, our court held that one bylaw was unintelligible and therefore was invalid. The remaining advance notice bylaws at issue were valid because they were consistent with the charter, not prohibited by law, and addressed a proper subject matter. And thirdly, the board had acted inequitably when it adopted the amended bylaws for the primary purpose of interfering and ultimately rejecting Kellner's nominations. As a result, the remaining bylaws challenged on appeal were unenforceable. Mr. Kellner ultimately lost the battle because we agreed he had submitted false and misleading responses to certain valid bylaws, and thus his nomination notice was invalid. I will discuss other aspects of this case when I later talk about linguistic tripwires. But let's now turn for a moment to statutes. In the recent case, In re Fox Corporation, Snap Inc., Section 242 litigation, our Supreme Court grappled with the plain meaning of the word power as it appears in Section 242b2. Following a new amendment of Section 102b7 of the Delaware General Corporation Law, both Fox and Snap sought to amend their corporate charters and expand liability protections for their officers. The new amendments would exculpate officers for duty of care damages. Both Snap and Fox had a multi-class stock structure with Class A common stockholders that had no voting rights except to the extent in the company's charter or as required by the DGCL. In both instances, each company's voting classes voted to approve the exculpation amendments. Neither company solicited a vote from the Class A stockholders. Obviously unhappy with that and believing they were entitled to a class vote, the Class A stockholders sought a declaration that the company's decision to vote on the amendments without their input violated this statutory provision, which in essence, just to pare it down a bit, states the holders of the outstanding shares of a class shall be entitled to vote as a class if the amendment would alter or change the powers, preferences, or special rights of the shares of such class so as to affect them adversely. And so the word they were focusing on was power and the power to sue. But note that it appears in the phrase power, preferences, or special rights. According to the Class A stockholders, the amendments to the company's charters adversely diminished their power to sue the company's officers for breach of their duty of care, and thus the language of Section 242b unambiguously required a class vote, they said. They raised several arguments based upon their interpretation of the word power. For example, they argued that stockholders have three fundamental powers: the power to vote, sell, and sue, because the dictionary definition of power includes the ability to act or not act. They also asserted, among other arguments based on certain case law, that the greater context of the DGCL supported a reading of power which associated the term with the ability to sue or be sued. The Court of Chancery, in a scholarly decision, acknowledged the merit of the Class A stockholders' contention, but ultimately disagreed that they were entitled to vote under the statute. And the court advanced four main reasons, and it really was a scholarly decision I can't go through in detail, but let me just give you the big picture points. First, the textual overlap between three provisions of the DGCL 242b2, 151a, and 102a4 suggested that powers must be explicitly outlined in the corporate charter to qualify for the protection of 242b2. Second, the court studied two cases, Dickey Clay and Orban versus Field, and felt that those demonstrated that power only referred to peculiar or special characteristics of a class of shares rather than rights incidental to share ownership. Third, no commentators supported the Class A interpretation of powers. And fourth, practitioners in Delaware had long interpreted the case law to support the company's reading. The Class A stockholders appealed, and our court affirmed the Court of Chancery's decision. We agreed with the company's argument based upon the text of the relevant statutes, Section 242b2, 151a, and 102a4 all included similar usage of the words powers, preferences, and special rights. The similar usage in each of these sections indicated that they ought to be read together. And when read together, the section showed that the power to sue an officer for breach of their duty of care was not a power under Section 242b2. In other words, we looked to other parts of the DGCL and included that it was not by accident that the same sequence of words was used in these other sections. The Supreme Court commented on the Court of Chancery's conclusion that the plain meaning of powers, preferences, and special rights was consistent with long-standing expectations of commentators and practitioners. We said in commenting on the trial court, the Court of Chancery determined that this evidence of corporate practice fit its understanding that in nearly 40 years since 1986 and the adoption of Section 102b7, no one has taken the position until this case that an exculpation amendment requires a class vote. Although the Class A stockholders argue otherwise, the Court of Chancery did not make practitioner experience central to its ruling. Instead, it simply observed that a statutory interpretation which deviated from the historical understanding would conflict with the stability of our corporate law. This observation regarding historical understanding of a statute raises the interesting question as to what extent long-standing expectations of commentators and practitioners should factor into the interpretive exercise. Several recent decisions wrestle more directly with this precise issue, and I'll segue into my next topic, which is, what is the role of corporate practice in the interpretive exercise? Our Court of Chancery has recently wrestled with this question in some recent decisions. One such decision is West Palm Beach Firefighters Pension Plan versus Moelis, where the Court of Chancery began its decision with the following question, and I quote, "What happens when the seemingly irresistible force of market practice meets the traditionally immovable object of statutory law? A court must uphold the law so the statute prevails," end quote. Because this case is on appeal, my discussion of it herein will be limited strictly to reporting on the decision issued by the Court of Chancery. The immovable object referred to by the Vice Chancellor was Section 141A of our statute, which provides that the business and affairs of the corporation organized under this chapter shall be managed under the direction of a board of directors, except as otherwise provided in the chapter or in the certificate of incorporation. The Court of Chancery observed that Section 141A is the source of Delaware's board-centric model of corporate governance. In Moelis, the plaintiff challenged the facial validity of various provisions in a stockholder agreement that provided Moelis founder, CEO, and chairman, Mr. Ken Moelis, with certain veto rights or pre-approval rights over various corporate actions and over the composition of Moelis' board of directors and board committees. The types of corporate actions that required Mr. Moelis' pre-approval included the entry into any merger, consolidation, recapitalization, liquidation, or sale of the company of all or substantially all of the assets, or a consummation of a similar transaction involving the company. The court noted that the pre-approval requirements encompass virtually everything the board can do, and because of them, the board can only act if Mr. Mullis signs off in advance. The Court of Chancery held that the stockholder agreement was void because the requirement that the board obtain Mr. Mullis' prior approval for significant corporate actions effectively and improperly delegated managerial authority to him and restricted the board's ability to exercise its independent judgment. In resolving the dispute, the Court of Chancery reasoned that the challenge provisions were part of an internal governance arrangement. The court observed that the only parties to the stockholder agreement were the company, Mr. Mullis, and the three entities he controlled. The parties entered into the agreement just before the company's shares started trading publicly. As such, it was subject to 141A. In short, the court found that because of the pre-approval requirements, the business and affairs of the company are managed under the direction of Mr. Mullis, not the board, and as such, the Court of Chancery held the pre-approval requirements violate Section 141A. The Court of Chancery reiterated that when market practice meets a statute, the statute prevails, and that unless the General Assembly acts, the statute controls. Well, that is exactly what happened next. The General Assembly and Governor enacted statutory amendments to legislatively override the Court of Chancery's decision. The amendments were intended to apply prospectively and retrospectively, but not to the Mullis case or to other cases pending at the time of the enactments of the amendments. Commentators have observed that the new amendments raise many issues, including whether counterparties to such agreements will be deemed controllers, and what happens when control rights via new Section 122.18 clash with a board's fiduciary obligations. These questions will have to await further developments in the law. Other commentators referring to the amendments as market practice amendments have questioned whether the amendments signal a change in approach for how Delaware corporate law will be evolved, shaped, and clarified. Again, only time will tell. In another case in 2024, the Activision Blizzard case, the Court of Chancery again wrestled with the plain meaning of statutory provisions and an apparent conflict with the long-standing expectations of legal commentators and practitioners. This case stemmed from Microsoft's 2022 acquisition of Activision Blizzard, a developer and publisher of interactive entertainment content. In January 2022, the Activision board received and approved a draft of the merger agreement. But the board neither approved nor received any subsequent, reviewed any subsequent version of the merger agreement, including the final and complete execution version. The draft contained several omissions, including the company disclosure letter and disclosure schedules, the certificate of incorporation of the surviving charter, and the amount of consideration paid, as well as Activision's name as the target. Placeholders were used for both. The Court of Chancery found that these items should have been included at a bare minimum. Activision later filed a proxy statement seeking stockholder approval. The proxy statement omitted the disclosure letter, the disclosure schedules, and the surviving company's charter. At a special meeting, the stockholders approved the merger with more than 98% of the stockholders voting in favor. In November, the plaintiff and Activision's shareholder filed suit in the Court of Chancery, alleging that the defendants had violated Section 251 and 141 of the DGCL by failing to include in the merger agreement approved by the board items required by statute. The Court of Chancery denied the defendant's motion to dismiss as to some of the claims. In its analysis, the court first focused on the statutory language. Section 251B requires that when a corporation desires to merge or consolidate, its board must approve an agreement of merger. Section 251B lists the information that must be included in an agreement of merger, such as the terms and conditions of the merger. The plaintiff in this case argued that the board violated Section 251B because the draft merger did not include all of the statutorily required terms, and thus the board failed to approve the final executed version of the merger agreement. Defendants responded that this narrow interpretation of Section 251B was not required by the statutory language and would also conflict with common corporate practice. The defendants emphasized that the plaintiff's interpretation would create uncertainty about the validity of mergers and would create uncertainty for third parties dealing with Delaware corporations and would disserve Delaware's longstanding public policy of encouraging mergers. The Court of Chancery rejected defendants' arguments. Instead, it determined that the plaintiff's interpretation found support in the plain language of Section 251B. According to the Court of Chancery, no matter how one looks at it, the draft merger omitted information required by statute. Although the court recognized that the plaintiff's interpretation did not square with the norms of market practice, it held that, quote, where market practice exceeds the generous bounds of private ordering afforded by the DGCL, then market practice needs to check itself, end quote. Following the Activision decision, multiple amendments to the DGCL were proposed and adopted. Notably, the amendments include new Section 147, which states that when a board is required to approve or take other action with respect to any agreement, instrument, or document, such instrument, agreement, or document approved by the board of directors in final form or in substantially final form. Other sections were added and amended as well. Let's move away from this area for a brief moment and talk about some intentional deviations from plain language in our law in Delaware. In a recent case in 2024 again, in the case Feral Gas Partners versus Zurich American Insurance Company, our Supreme Court considered whether a runoff exclusion in an insurance policy barred coverage. In the course of affirming our Superior Court's determination that it did, we considered the appellant's contention that even if the policy were not ambiguous, it should be construed in a way that permits coverage consistent with the reasonable expectations of the insured doctrine. We observed that because an insurance policy is an adhesion contract and is not generally the result of arm's length negotiations, courts have developed rules of construction which differ from those that apply to most other contracts. A fundamental premise of this doctrine is that the policy will be read in accordance with the reasonable expectations of the insured, so far as its language will permit. Let's turn to yet another area. Courts addressing bond transactions have sometimes deviated from the plain language interpretations. The court's willingness to do so generally revolves around efficiency concerns for capital markets. And on some occasions, courts have interpreted the plain language of bond agreements in ways surprising to those who regularly practice in the area. I'm going to take a little detour from Delaware for a moment. In the book, The 3.5-Minute Transaction, authors Mitu Gulati and Robert Scott sought to unearth the history and understanding of pari passu clauses in sovereign bond transactions. Pari passu clauses are an example of what the authors called sticky boilerplate, or standardized clauses that have been used by rote over long periods of time, often remaining unchanged, even when a court decision has created uncertainty regarding its meaning. And in 2000, a Belgian court issued such a decision. That year, Elliott Associates, in the case Elliott Associates versus Peru, sought an ex parte injunction in a Belgian court in an effort to obtain payment on Peruvian sovereign bonds. Elliott had purchased the bonds at a deep discount and refused to participate in a settlement agreed to by other bondholders. Because of this refusal, Peru sought to pay the settling bondholders, but not Elliott. Eliot pointed to the bond's pari passu clause to argue that Peru could not selectively pay its bondholders and that the court should grant an injunction preventing Peru from paying its other bondholders through Belgium-based Euroclear. In a decision that shocked the legal community and threw sovereign bond markets into chaos, the court granted the injunction, and before it could be appealed, political instability led the Peruvian president to settle the case. Thus, this decision continued to stand as the leading persuasive authority on pari passu clauses, and capital markets were left to process its chaotic effects. This interpretation of pari passu clauses led to widespread concerns about market stability. Yet surprisingly, the presence of these chaos-threatening pari passu clauses in sovereign bond transactions did not change. The author's research showed that even after the Eliot case, the clauses could be found in well over 90% of sovereign bonds. The authors interviewed hundreds of lawyers in the field, but could not find a consistent story that explained the clause or a consistent understanding as to what it meant. I thought this was an interesting example of the inertia that could develop over time to change standard language, even when a court disrupts the commonly held understanding of it. But let's go, and perhaps the inertia or stickiness is better explained as a concern. If the standardized language is changed, that would somehow be viewed as a concession that there were indeed defects in the prior versions which still exist in most of the bonds. And perhaps that type of concern is what animated some of the concern in the Kellner litigation, as other companies had similar types of bylaws that the trial court had deemed facially invalid. Now back to Delaware. In the Bank of New York versus Mellon Liberty Media case, the Delaware Supreme Court faced the challenge of applying plain language principles to boilerplate. In that case, Liberty Media sought to split off its assets as part of a plan to create a new publicly traded company. The boilerplate at issue was the series of transactions language in the successor obligor provision. So without getting into the specifics of that case, in an opinion written by Justice Holland, the court accepted Liberty's argument, giving weight to a uniform interpretation of boilerplate. The court wrote that successor obligor provisions in bond indentures consists of market-facilitating boilerplate language. Courts endeavor to apply the plain terms of such provisions in a uniform manner to promote market stability. There are decisions by Delaware courts where the courts have considered custom and practice in ascertaining the meaning and purpose of provisions, at least to the extent past practices are reflected in model transaction agreements. For example, in the H. Controls Holdings case, the Court of Chancery observed that in an M&A transaction, agreements are not created from scratch. Instead, they are based on provisions negotiated in prior deals and past practices, and lawyers negotiate provisions with knowledge of these past practices. It is not uncommon for Delaware courts to refer to model transaction agreements and related commentary and ascertaining the purpose of certain provisions. Now let me jump to another topic in our plain language world: strategic use of prolixity, complexity, and vagueness, tripwires. Let's go back to Kellner for a brief moment, the advance notice bylaw case, and to the notion of linguistic tripwires. Notably, in examining the advance notice bylaws at issue, our court affirmed the invalidity of an ownership provision, which was a 1,099-word run-on sentence with 13 subsections. The Court of Chancery commented that, quote, "It cannot say whether the ownership provision would choke a horse, but it has certainly flummoxed this judge." We agreed with the Court of Chancery that the provision was indecipherable. I was going to put it up here on PowerPoint, but I decided to spare you that. As such, it was not valid under any circumstances. I tried to think of another situation in which complexity and prolixity might be considered a tripwire by the court, and I found the word used in this Williams Company stockholder litigation case involving a shareholder rights plan. There, the Court of Chancery considered several challenges to a stockholder rights plan. The rights plan adopted during the COVID-19 pandemic was at the time unprecedented in that it contained a more extreme combination of features than any shareholder rights plan previously evaluated by the court. A 5% trigger threshold, an expansive definition of acting in concert, and a narrow definition of passive investor. The Court of Chancery, in describing the plan's key features as extreme, found, for example, that the plan's definition of beneficial ownership and acting in concert went well beyond federal definitions. The acting in concert provision, in the court's view, was the primary offender because its broad language swept up potentially benign stockholder communications relating to changing or influencing the control of the company. Moreover, it glommed onto this broad scope the daisy chain concept that operates to aggregate stockholders even if members of the group have no idea that the other stockholders exist. The court described the passive investor definition in the plan as another easily activated tripwire. The Court of Chancery ultimately declared the plan to be unenforceable, finding that the defendants failed to show that the plan's extreme, unprecedented collection of features bore a reasonable relationship to their stated corporate objective. Our Supreme Court summarily affirmed. Now I'm going to go to a new frontier for plain language. I'll conclude this talk with some musings about this new frontier. At first glance, let me go to my Schnell versus United Specialty Insurance Company, a case decided in 2024, seemed like a typical case. United Casualty Insurance Company refused to defend Mr. James Schnell, a landscaper, in a civil lawsuit alleging that Mr. Schnell had negligently installed a ground-level trampoline in a client's yard. Schnell sued, contending that United had breached its insurance contract with him in bad faith and sought a declaratory judgment that United had a duty to defend and indemnify him. This is what we're talking about. This is Mr. Schnell's in-ground trampoline. The district court granted summary judgment for United, holding that the accident did not arise from Mr. Schnell's landscaping work within the meaning of his commercial general liability policy. In reaching this conclusion, the district court noted that the policy did not define landscaping and that common everyday meaning of the word did not include trampoline installation, even under the definition submitted by Schnell in his briefing. Just out of curiosity, how many here think this is landscaping? Please raise your hands. Oh. Well, you disagree with the 11th Circuit, who said it was not landscaping, but that's okay. Schnell could have ended there, but a concurrence by Judge Kevin Newsom made this case stand out from the pack of plain language insurance disputes. Rather than being content with traditional plain language tools of the dictionary, Judge Newsom offered a modest proposal. He suggested using large language models to review the definition of landscaping as used in the insurance policy and how it fit in with the in-ground trampoline. First, the LLM search obtained results, and notably, they differed from the conclusions reached by the majority. His research into dictionary definitions revealed a more traditional definition. Webster's defined landscaping as to modify or ornament a natural landscape by altering plant cover. The others were similar. After languishing in definitional purgatory, Judge Newsom found no single discerning criterion. That is when he turned to ChatGPT. Upon asking ChatGPT, is installing an in-ground trampoline landscaping, ChatGPT answered, why, yes, it was landscaping. Installing an in-ground trampoline can be considered a part of landscaping, etc. And Google's Bard, since replaced by Gemini, returned a similar result to Judge Newsom's question. Thus, the outcome differed on the source consulted. Judge Newsom's concurrence also sketched out his view of the benefits and risks of using LLMs. These drawbacks included LLM's potential to hallucinate, their failure to capture offline speech and usages of underrepresented populations, a concern over manipulation by interested parties, and the potential for LLMs to create a dystopia of algorithmic robo-judges. No doubt, there are a host of issues raised by the use of generative AI by judicial officers. These range from ethical issues, data security issues, technical competence, among many others. Our judicial branch in Delaware has determined that some uses could be acceptable to achieve certain efficiencies. However, judicial officers should not use AI services to reach a decision or determine the outcome of a case or a disputed issue. In my view, guidelines on the assessment and procurement of AI technology are also essential, as is training if courts are determined to permit use of it within certain limits by judicial officers. In Delaware, we have a Law and Technology Commission, which I co-chair. Vice Chancellor Laster is on it as well. And we recently adopted last month interim guidelines for our judicial branch. Our commission has spent much time studying the technology, ethical, and other issues to keep our courts up to date in understanding how to function in this ever-changing technological landscape. Where is all of this new technology? Let me advance this. Taking us in the world of corporate drafting and the judicial process. The legal marketplace may force lawyers to use AI to increase their efficiency in drafting agreements, whether they want to or not. The private implementation of technology in the legal field carries both promises and pitfalls. New technologies have made the legal profession and the judiciary evolve before, and the growth of AI will continue to exert pressure on legal constituencies to change. How will this pressure affect the structure of law firms? How will it affect the courts when litigants are being pressured by clients to find more cost-effective ways to do things? I will conclude this segment with some thought-provoking predictions made by Richard Susskind in his book, Tomorrow's Lawyer, published by Oxford University Press in 2023. I don't necessarily align with his views, but I think they are thought-provoking. He said the bespoke specialists who handcraft solutions for clients will be challenged by new working methods characterized by lower labor costs, mass customization, recyclable legal knowledge, pervasive use of advanced technology, and more. And he also says in the years to come, conventional lawyers will not be as prominent in society as today. Clients will not be inclined to pay expensive legal advisors for work that can be undertaken by less expert people supported by capable systems and standard processes. As I said, I don't necessarily agree with these observations. I think there will continue to be a place for talented lawyers, particularly in doing the most sophisticated corporate legal work, but no doubt there will surely be pressure to learn how to function and adapt rapidly in this rapidly changing legal environment. The impact may be felt in the area of corporate drafting and in litigating these corporate disputes. I will end my musings about plain language in Delaware corporate law with a few observations. Discerning plain language may be more of an art than a science. While we strive to have rules and principles to achieve a level of predictability, as you have seen, it is often not easy for courts and parties to agree on what language means. Even some of the simplest and most common words can be the source of great dispute. It is my sincere hope that those who have listened so kindly tonight and those who read the article once it is published might in some small way benefit, even if it is to help us all be more focused on the importance of words we use in our drafting exercises. I will conclude by saying that I have presented a lot of ideas tonight and topics based on a number of our recent cases and a few interesting cases from elsewhere for your consideration. Perhaps they will encourage follow-up discussions tonight and later this week. I hope you have enjoyed hearing my perspective on plain language in Delaware corporate law, and thank you so much for your kind attention.
Thank you so much. Before I let you leave the podium, I think we have time for a few questions. And I see a bunch of students here, so I can always call on people. Yeah.
So thank you very much, Justice, for the interesting talk. So I just pulled up the provision from the Kellner case on my phone, and as a former M&A lawyer, looking at it, I don't know whether it would choke a horse, but it doesn't necessarily structurally strike me as unintelligible. Right? I mean, it has a lot of standard phrases like for the avoidance of doubt, directly or indirectly, that add to the length, right, but are generally understood. And I think that's a product of drafting largely being an exercise undertaken for an audience of folks who are familiar with that type of jargon. So am I correct to interpret some of the thrust of your argument to be that lawyers, when engaging in that sort of add-on kind of aggregate jargon, should be taking into account that these provisions could end up in front of a very different audience, right, who is not necessarily able to have all of the immediate kind of aggregated experience that allows you to gloss over those things, but is really taking each word into context and maybe looking up each word in a dictionary. Does that sort of square?
I think you have to step back a little bit and look at this from the court's perspective. It's a court of equity, and these provisions are meant for people who want to serve on a corporate board, and they have to be able to understand and to comply with them. And if they are so prolix and complex that you can't figure out exactly what is required, then that's just not fair from the standpoint. And some of those bylaws really got kind of way out of control in terms of prolixity. And if a judge can't discern what it means, then that's a pretty good determination that the people trying to comply with this bylaw are going to have a very difficult time. And so, and we agreed. We looked at it, and we couldn't make sense of it. So I think that the lesson from that is, yes, corporate drafters should be taking a look at these things for reasonableness, and it shouldn't be an exercise where it's so difficult for somebody to figure out what it means in order to comply. That's the bottom line.
So let me follow up on that. So at least when I was in practice many years ago, as a litigator, you looked at document requests, and the definition of document would be extremely long for obvious reasons, which was at some point in some case, some lawyer on one side or the other refused to produce something on the grounds that it was not a document. So there was a period of time, presumably, when people did not produce emails because they said an email is not a document. There are some people who think that characterizing an email as a document was the beginning of the end of Western civilization. That would be Ted Mervis. But it was an iterative process to avoid evasion. Is that a different situation than the situation of this bylaw that you're discussing?
I think the purposes are entirely different. Trying to capture what is a document versus putting something in front of people who have a right to try to run for a position on a board of directors and make it so complicated they can't figure out what it means, I think is a different situation from what you described. And I think there probably are ways to, I think lawyers, sort of like the pari passu clause, right? There's a certain inertia. We've used this definition of document for years, and we're not going to change it. And it's, we've used the same provision. And when you read it, it could be ridiculous. If somebody trying to write it from scratch would come up with a very clear, different version. But I think there's a lot of, this is the way we've always done it, built into some of this. I practiced for 25
Right.
years. I saw a lot
You
of.
saw the
I saw a
definition
lot.
of documents. Dan?
I'm curious if there's any, and I'm not a practicing lawyer, so apologize if this is a silly question. But in the bylaw situation, which is a unilateral drafting, is there any accounting for that versus I've seen MAE clauses that go on for pages. And it's, a negotiation. Does that factor in at all in terms of the interpretation that opposing parties sort of came to an agreement on this, as opposed to a bylaw that just they drafted themselves and put out there and you think is a little crazy?
Well, I think, I've never seen a situation where, anyone other than the companies, lawyers and the company personnel would be involved in drafting the bylaws. So it's not like a situation where there would be, people on the opposite side negotiating for the structure and the text of the bylaw. So I think it is different. Yeah.
We have a reception outside, but before we adjourn to the reception, please join me in thanking Justice
Thank
Valihura.
you.